Welcome back to the deep dive. Now, if you've ever had to stare down a really dense syllabus for something like corporate finance or risk management, you know the term tort law can feel like this huge barrier.
A huge wall of text.
Exactly. So today, we're tearing that barrier down.
And this deep dive is hyper-targeted. We're not here to read you a textbook. The goal is to distill the absolute core concepts you need for understanding professional liability.
Right.
So whether you're looking at the ACCA, LWE&G syllabus, or you're just trying to get your head around corporate governance, knowing who is responsible when harm happens is, well, it's essential.
It is. Our mission today is simple. We're giving you the shortcut. We're unpacking the single most crucial part of tort law, the tort of negligence. And then we'll apply that to professional negligence and vicarious liability. Think of it as the basic toolkit the law uses to assign blame and, financial responsibility.
And that financial responsibility, liability, that's why this matters so much in the business world. This framework, it really defines the boundaries of risk for every professional and every company out there.
Okay, let's unpack this then. We have to start with the fundamental building block. If we're looking for liability, we're looking for a tort. So what is a tort, and what makes negligence so special?
A tort, at its heart, is a civil wrong. It's an act, or even an omission, that causes injury or loss to someone else, and for which the courts will impose legal liability.
So not a crime.
Right. That's the key thing to grasp. A crime is a wrong against the state, and the result is punishment. A tort is a wrong against an individual, and the remedy is usually money. It's about making the injured person whole again.
So we're dealing with private claims for damages, and negligence is the big one here.
Oh, it's the most common by far. Negligence is really just carelessness that results in actual harm. The legal definition is pretty straightforward. It's failing to exercise the reasonable care a prudent person would, which then results in damage to someone else.
That sounds simple, but I'm guessing the law demands a pretty strict structure of proof. You can't just, claim someone was careless.
You can't. And this is foundational. The claimant, the person bringing the case, has to establish three things all at once. If even one is missing, the whole claim just collapses.
Okay, what are they?
First, a duty of care was owed by the defendant to the claimant. Second, there was a breach of that duty. And third, that breach was the direct cause of the damage. Duty, breach, causality.
Duty, breach, causality. Let's tackle number one. Duty of care. I hear that term all the time, but how is a legal duty actually established? I mean, I don't owe a legal duty to every single person on the planet, do I?
That's the critical distinction. You're right. The law has to draw a line somewhere. Historically, figuring out who owed a duty to whom was a real mess until this landmark case, Donahue v. Stevenson, back in 1932.
Ah, the famous snail and the ginger beer case.
Precisely. That's the one. And that case established what we call the neighbor principle. It basically says you owe a duty of care to people who are so closely and directly affected by your actions that you should reasonably have them in mind.
So if we translate that out of the legalese, it really boils down to two things, right? Foreseeability and proximity.
That's a perfect summary. The law asks, was the injury to this specific person reasonably foreseeable? And was there a relationship of sufficient proximity, a kind of legal connection between the two parties?
So if you run a red light, it's foreseeable you might hit another driver.
Exactly. Or a pedestrian. So you owe them a duty of care to drive reasonably. It establishes that legal boundary for responsibility.
Got it. Okay, so once a duty exists, we move to pillar two, breach of duty. If I had a duty to drive carefully, how do we prove I actually breached it? Is it about what I personally thought was careful enough?
Absolutely not. And this is where we get the famous concept of the reasonable person. A breach happens when the defendant falls below the standard of care expected in that situation. And crucially, that standard is completely objective.
So the law doesn't care if you were having a bad day or you genuinely thought you were doing your best.
Correct. We don't judge you on your personal best. We judge you against the standard of the ordinary, sensible, prudent person doing that same activity. The question is, would the reasonable person have acted the way the defendant did? If the answer is no, the duty has been breached.
Okay, so if I'm a professional, say a surgeon doing a complex operation, the standard isn't the ordinary person off the street.
It's the ordinary surgeon.
Right.
You're jumping ahead a little to professional negligence, but you're spot on. The standard is always benchmarked against a reasonably competent individual performing that specific skill.
That clarifies duty and breach. But proving carelessness isn't the whole story. You have to connect that breach to the actual harm, which brings us to the third, and you said often trickiest, pillar, causality.
Causality is the critical link. You can be as careless as you want, but if your carelessness didn't actually cause the harm, you're not liable. And we usually break it into two parts: causation in fact and causation in law.
Let's start with causation, in fact. That sounds like proving the direct link.
That's where the famous but-for test comes in. The court asks, would the damage have happened but for the defendant's breach of duty? If the claimant would have suffered that damage anyway, well then, the defendant isn't the factual cause.
But doesn't that but-for test get absurd? I mean, if a rusty guardrail I failed to replace causes a crash, I'm liable. But you could trace the chain of events back to the person who invented steel, couldn't you? How does the law stop that?
That's an excellent point, and it's exactly why we need the second step: causation in law, or what we call the doctrine of remoteness.
Remoteness, all right.
Even if you are the factual cause, the law says the damage suffered can't be too remote from the original breach.
So we're back to foreseeability again, but this time it's applied to the damage itself.
Exactly. It limits liability to the kind of damage that was reasonably foreseeable at the time of the breach. You might be liable for a broken leg from a car crash, but probably not for some rare, unforeseen allergic reaction to the hospital food 3 weeks later.
And what if something else happens in between? Say I'm negligently injured, but on the way to the hospital, the ambulance crashes because of someone else's mistake. Does that break the link?
That's what lawyers call a novus actus interveniens, a new intervening act. If a new, independent, and totally unforeseeable act occurs, it might break the chain of causation. But if that intervening act was a reasonably foreseeable consequence, like, say, a doctor making a routine mistake during surgery for the initial injury, the chain might stay intact.
I see. So the original person is still on the hook.
Potentially, yes. It's a messy area, but it shows how carefully the law tries to apportion responsibility.
Right. Understanding those three elements, duty, breach, and causality, that really is the roadmap. So how does this whole framework shift when we start applying it to professionals? Let's move on to professional negligence.
This is where it gets really specific for our listeners. Professionals, auditors, accountants, engineers, they're held to a specialized, elevated standard of care, just like you said earlier.
So they're judged against the reasonably competent professional.
Precisely. They have to exercise the skill and care expected of a reasonably competent person in that specific field. An auditor is judged against the standard of a reasonably competent auditor. They can't say, well, the general public wouldn't have spotted that.
So why is this so crucial for auditors and financial professionals? The stakes must be way higher than just one driver owing a duty to another.
The stakes are exponentially higher, mainly because of one word: reliance. With a car crash, the duty is physically obvious. But in professional negligence, the duty often extends to third parties who aren't even the direct client. This is where we run into the problem of pure economic loss.
Which is financial loss that doesn't come from a physical injury or property damage.
Yes. And for a long time, the law was very reluctant to allow claims for that. But cases like Headley-Byrne established that a duty of care could exist for negligent statements, like an audit report, if there was a special relationship between the parties.
And that special relationship is all about reliance, isn't it? The accountant knows, or should know, that some third party, an investor, a bank, is going to rely on their expert findings.
That is the core legal mechanism. If an auditor breaches their duty, say, they fail to exercise proper care in verifying key figures, and that breach causes foreseeable financial loss to someone who relied on that report, the auditor and their firm can face massive liability. The standard is higher because the consequences of carelessness are systemic.
That puts incredible pressure on an organization's internal processes, which gives us a perfect bridge to our next concept, vicarious liability. If an individual auditor is negligent, when does that liability travel up the chain to the entire firm?
That is exactly the function of vicarious liability. It's a separate, sort of policy-driven idea in tort law that lets the law hold one person, usually an employer, responsible for the torts of another, even if the employer themselves wasn't negligent at all.
So it just shifts the entire risk management burden onto the organization?
It does. The rule is that an employer is held responsible for negligence committed by their employee, as long as the tort was committed in the course of employment.
Okay, let's clarify. In the course of employment, does that mean the boss is liable for literally everything an employee does between 9 and 5?
No. The courts look for a sufficient connection. If the employee is doing something authorized by the employer, even if they're doing it in a negligent, unauthorized way, the employer is usually liable. So, a delivery driver who carelessly causes an accident on their route, the company is liable.
But if that same driver takes the company truck out after hours to go street racing,
The link is broken. Exactly. The courts call that being on a frolic of their own. If the act is totally unrelated to the job, the employer is usually off the hook.
what's the thinking behind this doctrine? I mean, why hold an employer liable for what someone else did? It seems, on the face of it, fundamentally unfair.
The rationale is highly practical. It's policy. There are two big arguments. First, the employer is usually in a better position to pay compensation. The deep pockets argument. It ensures the victim gets paid.
Right.
And second, the employer is the one who puts the employee in the position to cause the harm in the first place, and they benefit from that employee's work. So the thinking goes, they should also bear the cost of the risks created by that work. It's a huge incentive for good training and supervision.
That makes perfect sense. It's a form of corporate risk internalizing. If you benefit from the work, you own the downside.
Creates a very powerful incentive for good corporate structure.
This has been an incredibly fast but necessary run-through. Let's just quickly recap the knowledge nuggets to make sure everyone has this framework locked in.
We started with the three essential parts of negligence: a legal duty of care, a breach of that duty based on the objective reasonable person, and causality linking the breach to the damage.
We then applied that to professionals, noting that people like auditors are held to a higher standard, that of the reasonably competent professional, because of the high reliance on their work and the potential for pure economic loss.
And finally, vicarious liability, which makes sure employers bear the legal responsibility for the negligent acts of their employees, connecting individual performance directly to corporate risk.
So if we connect all this to the bigger picture, you can see that tort law is this continuous balancing act between personal freedom and accountability. But for a professional, that act is even more intense. The law is still struggling to define who exactly an auditor owes a duty to when reliance can spread globally. And that raises a really important question for you to think about. If the legal standard struggles to fully cover every single person who might rely on your professional work, how should you, as a financial professional, define your own ethical duty when you know external stakeholders are relying entirely on your expertise?
And that really is the ultimate tension, isn't it? The gap between the legal minimum and the professional imperative. It's something to keep in your mind as you progress.
Absolutely. Well, you now have the essential framework to navigate professional liability and risk. Congratulations on taking this deep dive.
Good luck on your journey, and we look forward to the next one.
We'll catch you soon.